Greetings, this is James Tracy. Welcome to this edition of Real Politik on Truth Frequency Radio. Our guest today is Shawn Abrell. Shawn Abrell has been a practicing attorney since 2001 in both Oregon and the state of Washington. He is regarded internationally as the leading attorney for charitable work in the ultra-complex areas of civil rights and electromagnetic radiation. Mr. Abrell is versed in all aspects of personal injury and medical malpractice insurance, UCC and banking. He is a highly qualified and skilled professional in complex state and federal civil litigation. He holds degrees from Indiana University and Nova Southeastern Law School. Greetings, Shawn Abrell.
Hello, Professor. Thanks for having me on again. Well,
it's great to have you on the program once again. I had you on the initial incarnation of this program, which was hosted on my website on memoryholeblog.com, and this, of course, is on Truth Frequency Radio. I wanted, first of all, Shawn Abrell, to go over your background and some of the areas that you are looking into specifically today.
Oh, thank you. Yeah, I would just say that I became after graduating law school. I came out to graduating law school from in Florida. I came out to Oregon, where I ultimately became licensed in the state of Washington, and I worked for a law firm who a gentleman came to the firm, and he wanted to get Wi-Fi removed from his schools. And the case was a little too political for my firm, so they didn't want to handle it, and I took the case on by myself. And through that case, I got to work with some of the world's top experts in essentially every field of relevant science, and that was quite a few of them, including, starting off with just electricity itself, biology, microbiology, physics, and how all these things interact. Even public health, even epidemiology studies, different types of. I had to become understanding the different types of studies that are even out there, in vitro, animal, human.
You told me at one point, for example, that it took you tens of thousands of hours to go through all of the science related to this phenomenon.
Yeah, it just before we could even file a lawsuit, I think I spent about 4,400 hours just preparing so that I would understand the science enough to argue the facts enough to argue the law, and which is complicated in and of itself. And so that lawsuit, which kind of brings me into, I don't want to spend too much time on that lawsuit, but I did get to work with some of the world's top experts from all over the world. And one of them I will mention a little bit later was Barry Trower, who was a former microwave secret agent for the British Secret Service, or for the British secret agencies. And he was what he considered, he was, quote, a secret agent, which has a term of art, but that's neither here nor there. But he debriefed spies in the Cold War, and he essentially, when he found out that they were using the same frequencies that they used in the Cold War as weapons, as Wi-Fi transmitters in schools, he came out of retirement, broke the Official Secrets Act, and told what he knew, and has been going around and trying to educate people on the harmful effects of these essentially directed energy weapons that are being deployed and marketed as AKA Wi-Fi all around the globe now. When safer cable systems exist that don't emit any type of either extremely high frequency radiation or even extremely low frequency radiation. So those are the two types of toxic agents that we're trying to protect the kids from these wireless devices. And the actual term that we're talking about is pulse-modulated microwave radio frequency radiation. That's the toxic agent. That's carcinogenic, genotoxic, tetragenic, and I have expert witnesses who have sworn depositions filed in federal court to that effect, and the fact that one of the leading public health officials in the United States is Dr. David Carpenter from the University of Albany, and he said the strongest evidence is for cancer. But we've proven it on all of the different studies, and not quite the epidemiological studies, but because they take time, and that's what we found in that lawsuit was the amount of corruption that is prevalent in the world of electromagnetic science is profound. And what I had the wonderful opportunity, though, out of that lawsuit was I got to take the deposition of Dr. David Savitz. Dr. David Savitz is or was at the time, I believe he still is, the epidemiological chair, or the chair of the epidemiological committee for the ICNIRP, which is the International I'm sorry, I can't think what the acronym comes to me right now. International Commission on Non-Ionizing Radiation. And so I got to take his deposition, and the amount of, although they're not exactly paid for those positions, they wind up getting contributions from industry funding through other organizations that they're associated with or work for or on the boards of directors of or who have stock with. All these people have, a lot of these people have, these scientists have stock in these electrical power companies, these energy companies, telecommunications companies. And so we got to take his deposition. I got to take his deposition in that case, and that is public record. Anybody can type that in. The deposition of Dr. David Savitz. They can look it up and look at what was said about his interactions with other scientists who head up ICNIRP committees. And ICNIRP is the international organization that sets the standards which the WHO, or the World Health Organization, adopts. So it's a subset of the World Health Organization, and it's a very powerful rules promulgating body. Now, most people would think, that was a government-funded entity. It may be now, but initially it was started off by Michael Rapicelli, and I believe I'm saying his name right, but he is a clearly industry-funded scientist who initially was funneling money through a charity hospital in Australia to fund it, and it was initially all funded, and that came out a few years ago, and I believe they changed their funding sources. But the extent to which the telecoms have gone, and even the government to some degree has gone to hide the harmful effects of what is microthermal radiation, and because non-ionizing is just a term of art that was created by the military in the 40s to downplay the effects of microwave radiation below the thermal heating threshold.
This has to be along the lines of working within a hall or column of mirrors, because you are arrayed against major corporations, major foundations, governmental entities, and who is actually going to provide you with information that is substantial, that is reliable? It's got to be tremendously daunting.
Well, what's interesting is I think by 1980, there were 20,000 studies published regarding the biological effects of non-ionizing radiation, and more than that published about ionizing radiation, even more if you total it all up. But the amount of corruption from these now the telecoms back in this has been going on since the 90s, since the cell phones came on board, and what they've done is they've hired so many scientists who either create a design flaw study or skew the conclusions, or a number of different types of bias that can go into creating a study or reporting a study or summarizing findings. I can go on and on. And those are the types of things exactly that we cross-examined Dr. Savitz on, the ICNIR commissioner, and we held his feet to the fire. And people can read about those, what we asked him, and about the actual details of certain studies he was relying upon, and how what they're saying just simply is wrong and misleading. So what they wind up doing is they have all these scientists out there all over the world, and oftentimes you'll know the result of a study by the names of the scientists who are the authors.
All right.
And it's a pattern. I can name the names: Anders Albaum, Rappacelli, Feisting. I could go on and on. And these people are what we call the usual suspects. That's what I like to call them. Mm-hmm. And pure corruption just oozes from them. And they, openly support telecoms and the fact that there's just no associations in this and that. Now, how can they make that statement? Because what they've done is, over the years, they've created tens of thousands of studies. And what they say is that when they do a review of these studies, which they cherry pick, the weight of the studies, they say, doesn't support an association of harm. Now, they fail to mention that if you Henry Lai from the University of Washington did a paper, I believe he found that I think it's 70% of non-industry funded studies show an association. Mm-hmm. So what happens is that's what becomes the official position of ICNIR, which becomes the official of IARC, which is a subset of ICNIR, which sets their standards. And that then becomes adopted by the World Health Organization, who then adopts that, who then the United States adopts as the standard of safety. Now, what is the standard of safety again? It's the amount of energy it takes to begin heating up your body like a microwave oven does. And by the way, cell phones, wireless, use the same frequency, 2.4 gigahertz, as do microwave ovens. So they have the most harmful effects because of the reason a microwave oven works is because it's the frequency that has most resonance with water, and so heats up water the most. So anytime you're cooking up your food, you're heating that water, and so the same thing happens in the body. The body resonates because we're made of 80% water or more. The body's water resonates with this and absorbs the radiation. So it couldn't be a more real deadly weapon, and certainly is a Trojan horse, in my opinion. And I'm sorry?
Yes, go ahead, please.
So that's my opinion on cell phones, smartphones. They're being marketed, this toxic agent's being marketed as these smartphones, and it's giving people the ability to communicate instantly, to essentially have the world at their hands, but they're not. They're totally misrepresenting the harmful effects. And Steve Jobs, I believe he knew. I know he knew, and about the harmful effects of some of these, the radiations from the iPads is astounding. And even if you have it turned off in Wi-Fi mode, the amount of dirty electricity coming off the touchpad surface is around 50 milligauss. And recently they had a school on the eastern coast, I believe it was in Vermont, that was closed down because the amount of dirty electricity coming from power lines over the school was 7 milligauss. They closed the school down for 7 milligauss. Why is that? Because 2 milligauss has been proven, some studies show 1, to cause cancer. And how much milligauss dirty electricity is being let off of a touchpad, even with Wi-Fi turned off? Over 50 on the ones I've measured. So we have an unbelievably dangerous device that's being given to our children in schools, and they're not being given the warning labels. They're not told not to touch the device or keep the device an eighth away from your body when they're required to touch the device to even operate it, because that's how it interacts with the child, is because the device interacts with the child's electromagnetic field. Right. And the child grounds out and discharges all of that dirty electricity and or extremely high-frequency radiation. So those are two, that device there alone. Now, that device, speaking of that device, I think the last time I was on with Joe Imbriano, who is a student, a parent down in Fullerton, California. And the use of those devices in his classroom and in classes in the Los Angeles Unified School District, those students, when they turned on the new Wi-Fi system that they got and gave them iPads, those children began getting bloody noses. And I've heard reports, I've got about 5 school districts now in the state of California with bloody nose kids. And in the LAU SD, the protocol for dealing with this is that they don't have a nurse at school every day like they did when I was a kid. You could go down to the nurse and check in if you had a cold, and generally your mom came and picked you up. Sure. Not anymore. These schools, they have a nurse that comes around once a week on Friday, kind of makes her rounds, and the kids that were reporting bloody noses, those kids were told to go to the principal's office because there's no nurse's office, and the principal's office would just tell the kids to wash their face and go back to class. No records were being kept of this. Parents weren't being told this. There's photos of these bloody noses. We've got photos of this. I can't release them, but we've got them.
This is down in the LA Unified School District?
That's correct. I would say, and then Fullerton's close to that district, right, if not touching.
Yeah. That is absolutely amazing. And yet, even if there were a nurse that were there on a regular basis, sure, they would be able to document the fact that there were these incidents of these bloody noses, but would they have the knowledge, or would those, the medical authorities that those nurses depend upon have the knowledge to determine, to conclude that this is correlated with or related to the installation of the Wi-Fi?
Well, what they could be doing is keeping records. And what the, I think that the typical nurse out there is going to be open to any type of causation, and quite frankly, they don't really have to rely upon the nurses. A lot of these kids now have become diagnosed, and most of the times the parents have to pull them out of school, and but sometimes you can't afford to pull them out of school or whatever it may be. But is the nurse qualified? And I just got to have faith in the nurses that if they were made aware of the potential for the problem, because I could give you protocols that we have for doctors for diagnosing electrohypersensitivity. And the best evidence is seen by taking the kid in and out of the Wi-Fi environment, a.k.a. when he goes home from school. And by the time a lot of these kids get home from school, their symptoms, the bloody nose is usually stopping to get out of this school, and their other symptoms usually stop later on that night.
Well, a lot of homes now have Wi-Fi as well. Now, is what you're suggesting that the Wi-Fi in the school environment is so intense that it's beyond anything that might even be experienced in a home with Wi-Fi?
Well, you got a good point there. When you get a classroom full of kids all using iPads, I don't know what the range is of the dirty electricity, but the cumulative effect of the Wi-Fi signals bouncing around the room and peaking out at, quite frankly, a sea of places in the room, and probably an infinite amount of places, and continuously at various places, you're going to get a peak. And those peaks are certainly, I don't know if they're going to, cause thermal heating, but they're beyond the amount that has been proven to cause extreme adverse biological effects.
Yeah, if you've got like 20 or 25 of these iPads that are going off in one fairly small, size classroom, say 20 by 30 feet or 30 by 30 feet, that is, you're right, considerably more so than what one would experience in a domestic environment.
Yeah, absolutely, and quite frankly, we were very surprised to find that it was actually causing bloody noses. And because up until this year, we hadn't had those reports, up until the spring of 2013. And apparently what it was a combination of the touchpads and the routers. A good point you make is, although there's no safe use of any of this technology, there's not a possible safe use for a touchpad. And no child on the planet should be given a touchpad. You should even be you should be forced to sign a release of claims acknowledging the health effects if you even own an iPad. So until you're 18, you don't have consent anyway. So these devices should not be given to kids.
You're talking about anything that it would be connected wirelessly to Wi-Fi.
Absolutely, yeah. And I'm sorry, I've kind of lost my train of thought there. And so there's no safe use for these devices at home or at school. Now, at home you're going to have a router. It comes with your cable box, or your you just have a separate router for internet, and that's going to have a 2.4 frequency, 2.4 gigahertz. The ones at the school, interestingly enough, are what's called a dual band, and they're oftentimes a commercial grade, much more powerful, probably go 100 yards each transmitter, but they're also dual band. They're 2.4 gigahertz, and they're 5.0 to 5.2, I believe it is.
Okay, so they go 100 yards, and what does something at home go?
Well, the one at home the type ends, I guess, will go down to the end of the block, about the same range.
Okay.
But in schools, they're finding that one router can't handle 30 kids. So guess what they're doing? They're putting 2 of those puppies in sometimes each room. And so we've got 4 transmitters, 2 at 2.4 gigahertz, and 2 at around 5 gigahertz. And the 5 gigahertz is never, ever used. There's no devices that use those frequencies. So it's a complete overkill. It's reckless, is what it is.
Shawn
there's
Abrell,
absolutely no use for it.
Shawn Abrell, I want to hold on right there, and we'll pick it up in one moment. We're speaking with attorney Shawn Abrell, who is giving us a lot of very important information concerning Wi-Fi, the sort of technology that we coexist with on a regular basis. We'll be back with more here on Truth Frequency Radio, Real Politik. Welcome back. This is James Tracy here on Truth Frequency Radio, the Real Politik program. We're speaking with attorney Shawn Abrell on the dangers of Wi-Fi, electromagnetic frequencies, RF, EMF, and the whole 9 yards. He is an attorney who is very much involved with and versed in research concerning these matters. And we were talking about the dangers of Wi-Fi, specifically located in schools, located in almost every public school throughout the nation these days. Shawn, please continue.
Well, thank you, Professor. What we were talking about was iPads, and interesting thing, and ongoing potential litigation in California. It turns out these devices are essentially education media, and they are also toxic agents as defined by the World Health Organization as being any possible or potential agent which causes increase in carcinogenity in animals, according to the World Health Organization. So it meets the definition of a toxic agent per the California Education Code. So it's illegal that they could even buy these types of routers to educate via the internet, because that's all it is. It's a medium for which they educate via the internet, because you can also educate via the internet with a cabled system that is 100% safe. It's also more reliable and more secure. So when students are taking their exams, there's not going to be the ability to cheat as much with a wired system. Mm-hmm. And it's also faster and more secure. Right. So there is no downside with the alternative. So the question becomes, why would these schools want to go out and spend literally hundreds of millions of dollars? I think in the LA Unified School District, I think they spent $1.25 billion on the rollout of their wireless infrastructure. Now, why would you want to go and spend all of this money on devices that have never, ever, there's not one single study on planet Earth, and there's not one single scientist brave enough or willing to state that this technology is safe? Not one. And most people think that these devices are pre-market tested, like they used to be when I was a kid. When I was a kid, all of our toys had to be pre-market tested, and it was a big thing back then.
Right.
And most people grew up in my generation thinking that all products are pre-market tested. Well, not with cell phones. And those were specifically exempted from pre-market testing so that they could roll them out and begin generating a profit. And who, by the way, gets the profit? The Federal Reserve gets the profit. And without going into what the Federal Reserve is, those who know where that goes to will know where that goes to. And so you see that where the profit, because the Federal Reserve is entity that auctions off the frequencies that are owned by the people. And they take and turn that into money for themselves. Mm-hmm. So they're the ones profiting off this. And not only that, the same people that are profit from the Federal Reserve are the people who own the telecom companies, for the most part. Although what's happening is a lot of retirement funds in the United States are backed or heavily invested in telecoms, and that's because it's the only way they can generate returns. And a couple of years ago, I believe the first report from Lloyd's of London came out in 2011, stating that they would no longer insure any telecom companies or liability for any claims. And so that was based upon their findings. And that's a Lloyd's of London report that's available on the Internet. I believe there's an updated report from either 2014 or 2013.
Now, when you say the Federal Reserve, you mean that the Federal Communications Commission essentially acts as an intermediary in terms of licensing and overseeing this whole science or what passes for such.
Exactly. So the FCC issues the licenses, and that was all done in a lottery back in, there was two different lotteries, I understand, and Dr. George Carlo, mm-hmm. who was the, at one time was the president of the CTIA, which is the Cellular Telecommunications lobby effort, and they have been around since the early, mid-90s, and he was the head up of all that. And they gave, the government was licensing off these bandwidths, and they essentially licensed them off, but a lot of the people the prices that they went for prevented anyone from really buying them who claimed to have the money, but they really didn't. Mm-hmm. So the government became the backer of those debts, and from there on out, the FCC essentially became the financial backer through the Treasury of the electromagnetic frequencies that they're licensing off. So I guess the relevance of all that, as far as my interactions, was that in our first Wi-Fi case, it became very political, and the judge essentially washed his hands of the case and told me to take my case to the FCC.
Now, this was in Oregon?
That was in Oregon. That was the very first case.
Mm-hmm.
Yep. And he kind of pulled a Caiaphas and washed his hands of the whole thing and told me to take my complaint to the FCC. So that's someone tried that, I think, in about 2007, and his petition is still they haven't responded to it yet. So now there were a couple of legal arguments that we made in that case, but I want to just give you an update on what's happened on the Wi-Fi front since California. California, we're about to file a lawsuit there. It's going to involve the use of these technologies, like we spoke, not only Wi-Fi, but the use of the devices that the children use.
Well, why don't you provide that for us? But also, you mentioned the case in Oregon, and there's also another case I think that you also mentioned we talked about briefly beforehand in Washington. Could you provide us an update on that?
Yes, correct. Following California, last year, July of 2013, a mother by the name of Karen Knoll in the state of Washington, who is a cancer survivor, and she became more aware of the harmful effects of electromagnetic radiation from her own condition, and she did not want to expose her children to these technologies, and for fear of their life. And she sent a letter to the school, I believe the principal at first and maybe the superintendent, the school district, and asked them if they could give her a good reason why wireless was being used as opposed to a safe cable system. And, of course, they didn't. I think it was 6 months before they didn't respond, and she wrote them a second letter and went a little bit higher up the food chain. And they didn't respond to that one for 30 days, I believe. And she wasn't happy with the response, and so she CC'd the next letter, or maybe she didn't even get a response, but wasn't happy with her decision, and then CC'd the some legislator people. And when they CC'd the legislative people, they agreed that they would look at the topic and take it under consideration and give essentially a recommendation, is exactly what they promised. Now, that was what she knew at that time. So what ultimately happened was they formed a group, which is essentially two people who had very little, no medical background or anything like that, although they did consult with the Department of Health, but midway through, I believe, the person working for the Department of Health left the agency. So I don't know if there's any real support that ever actually came from the Department of Health. So it was a technology services director at the district who provided this opinion, this health-based opinion. And so in December of 2013, maybe January, I believe they came out with their preliminary report. And interestingly enough, it was extremely strategically worded and planned out, obviously to conclude that that their conclusion is that there's the weight of the evidence essentially is, and the opinions from various World Health Organization, ICNIRP and IARC and whatnot, is that there is not yet an association of harm based on the weight of evidence. Now, interestingly enough, in that case, once that came out, my client became very skeptical about what was going on, and so she did a Freedom of Information Act request. And I don't know when that was done, maybe I think after the first report came out. And so she got back, interestingly enough, some very interesting emails, and the emails were between school officials, and they called her a crackpot. They made fun of the parents from her school district, using expletives that were crossed out and whatnot, and stated in an email that they were essentially going to quote unquote do due diligence on this one and deal with it that way, so that they could claim they did their due diligence, but with the complete facially showing that what their motives were here, and that was just to make it look good, and that ultimately becomes the whole decision for the state of Washington is based upon the personal beliefs of these a couple school technology specialists who was probably the person who lobbied for and got the government grants for and rolled out the technology, and who probably believes in it.
Right, but they have no evidence in terms of its ill health effects or lack thereof.
That's correct. But the problem was it showed their bias from the beginning,
right,
and that they were going to come down a certain way. Now, what was interesting was the way they went about doing it was they decided that they would only consider what a type of study called a review, which is a summary of the weight of evidence, essentially, or whatever the review author wants to cherry pick out of the weight of evidence, which is the 20,000 or more studies that are in existence. And you could rely on the government's own studies from the 70s, the 60s, which list all of the biological harmful adverse effects from microthermal radiation or non-ionizing.
Those include military studies as well.
Absolutely, absolutely, and some of those are the most convincing. And so they cherry-picked these studies. Of course, they relied on ICNIRP, the International Commission on Non-Ionizing Radiation. The people who their head epidemiologist, from the chairman, who I took his deposition of, who is clearly industry funded and has a long career of it.
One of the things that strikes me, Shawn, Abrell, you mentioned earlier on in the first segment of our show, is that this very term, non-ionizing radiation, is a sort of public relations ploy.
Yes, it is. It's all part of the dumbing down of America. It's for people who want to drink fluoride. And I have a hard time even dealing with scientists because I have to educate them. For example, let's take the precautionary principle. The precautionary principle is almost certainly an industry idea, and it's to create doubt. I believe you're probably familiar with, I can't remember the name, but The Creation of Doubt. It was a book about how the tobacco industry creates doubt through studies. And those same strategies are being used by the telecoms since the 90s that were used by the tobacco companies in the 60s and 70s. And to create doubt. Now, the precautionary principle, it says if we are uncertain about the harmful effects of something, this came out of the European Union, I believe, then therefore we should not use that product until, we should use precaution or the least the least amount of exposure to these things as possible until we do know. Well, that sounds great, but in American jurisprudence, you have to have proof of harm before you can get anywhere. But that's only because they don't require pre-market testing. They exempted these technologies from pre-market testing, and aside from that, you would so there's no regulation, right? These devices are 100% unregulated at these frequencies. And that's why all of these devices are operated at those frequencies, because it's unregulated. They don't have to prove their devices are safe. And that's a specific exemption through the Telecommunications Act that was given to these for anyone using these frequencies as a commercial device.
And in addition, the whole notion of the precautionary principle suggests that there are going to be studies that might at some point be produced over a long period of time that do in fact suggest ill health effects, but those in fact never take place if these things are just almost immediately introduced into our environments.
Exactly. But about the precautionary principle, I'm sorry, I want to digress, and that it's a term of art. It implies that there's no proof of harm, but I can prove harm. There's more than 10,000 studies proving harm, and in fact, one group I've got a list of 50,000 studies about all showing harm, and that was all compiled by a group, I believe, in England. But so if you get someone in good faith, either a scientist in Europe, they want to argue the precautionary principle, or someone trying to argue to their school that Wi-Fi is bad. So you say, well, you should use the precautionary principle. Well, implied in the precautionary principle is you can't prove harm yet.
Mm-hmm.
Well, that's a fallacy. That you're just playing right into the weight of the evidence argument, which is a complete fallacy, and is a complete industry device to manipulate, studies and to manipulate the presentation of science how they want it, so that they're not going to be liable for it. And it's a complete part of brainwashing. But it's hard sometimes to convince some of these scientists not to argue the precautionary principle. In Europe, in some places it works because it's law. They're required to use least available means to prevent the exposure.
Mm-hmm.
But in the United States, that's not the law. And the law is here, you got to prove harm before you can even have a claim. And to some degree, even if you can prove harm, you still don't have a claim because the Telecommunications Act prevents anyone who would be injured from, say, a cell phone after 2006, when it was apparently adopted. This clause was adopted in 2006, apparently.
So 10 years after the Telecom Act.
Yeah, exactly. That's when they began to get sued, and then they inserted a clause, apparently. But I don't know when that clause came in, but a judge recently ruled and allowed forward, I believe, 30-some cases, cell phone cases, based on the harmful effects. And he said that clause that took away the right to sue these telecommunications companies if you get brain cancer, or if your kids come down with leukemia,
mm-hmm.
or whatever it may be, it takes away the right of anyone to sue. Now, they said that, however, if you had a claim that came about before 2006, that it would not be preempted. So that allowed about 30-some plaintiffs to come forward. A federal judge has recently, within the last few months, allowed those cases to proceed forward. So they're the first cell phone, and these are some big-time judgments that are going to go out, and these are going to be the first cases. But if you got a brain tumor after that, or the cause of it was mixed, or your claim didn't accrue till after that, then you're out of luck until Congress takes that clause out. Now, interestingly enough, though, what you're going to see in the future is the judge in that case said that was for essentially tort claims or personal injury claims. But he also said that misrepresentation claims or unlawful trade practices claims.
Call is now being recorded.
Oh, sorry, Professor. They sometimes start recording my conversations. So as far as the personal injury claims that the judge is allowing, all the ones before 2006 are allowed based upon the exclusion, but claims for misrepresentation, unlawful trade practices, deception, misrepresentation, fraud, those are not going to be preempted. And so plaintiffs' lawyers all over the United States should be getting ready to sue these, they should be drafting lawsuits, and as I will be doing soon, to bring claims based upon misrepresentation.
Shawn Abrell, we just have a couple of minutes left, and I wanted for you to be able to at least summarize this present lawsuit that is going forward in California.
Okay, the lawsuit in California. It was Washington. Oh, no, we did talk about Washington.
Yes. Mm-hmm.
The California lawsuit would be, it's based upon the state education code, which prohibits the use of toxic substances. And it prevents schools from buying education media that is defined by the state as a toxic substance. Mm. Now, based upon the recent World Health Organization upgrade of pulse-modulated microwave radio frequency radiation and other sources of microwave radiation as a type 2 possible carcinogen, which is just below probable carcinogen, which is a type 2A, which is just right below known carcinogen. Now, this is in the classification of DDT. Not DDT, but lead, exhaust from cars, and some other horrible compounds that you know would not be good for use inside of a school building.
Right.
Or anywhere else for that matter. Now, the California suit, so that's going to be a claim based upon the violation of the education code. And that's what that claim is going to be about. Mm-hmm. And it will be involving probably about 5 school districts all over the state of California.
Well, Shawn Abrell, this is all very important information, and I want to thank you very much for joining us today on Real Politik to update us on this.
I appreciate it, and there's just so much information on this topic out there. It's hard to get it all out in 1 hour. So I appreciate the time, and everybody appreciates what you do, and what you do is incredibly a brave thing to do, and we all appreciate that very much as well.
Well, thank you for being here, Attorney Shawn Abrell. We very much appreciate it. You're working on some very interesting and important things. We're definitely going to have you back in the future to give us updates. That's all for now. This is James Tracy, your host. Until next week, do take care.